Now I am going to dictate a legal passage based on High Court's judgment. Let's start. The sketch map exhibit 16 was prepared on 28/11/2003 to show place of occurrence and not the place of recovery. Stop. It was pointed out in the sketch map that Office of Central Excise stands to the west of the place of occurrence. The Exhibit 7 therefore is neither in contradiction with Exhibit 14 disclosure nor is it at variance with Exhibit 16 sketch map. Stop. According to her, Exhibit 7, Exhibit 14, Exhibit 16, the endorsement in the case diary and depositions of PW 17 on re-examination finally established beyond reasonable doubt that discovery of the revolver bearing number 35235 was made on being shown by the accused himself in presence of witnesses and show Section 27 of the Evidence Act has been duly complied with. Stop. Para. Coming to the question of ballistic report, she argues that there is a malkhana in Jorhat police station in terms of Rule 63 of Part 4 of the Assam Police Manual. Stop. The offending revolver was kept in safe custody in this malkhana till 24/12/2003. After its discovery, it would appear from the deposition of PW 17 that the arms and the ammunition were sent to Forensic Science Laboratory on 24/12/2003 by the memo number crime /2003/7832. Stop. They were first sent to Fingerprint Expert Bureau on 24/12/2003 for fingerprint examination. Stop. The fingerprint expert returned them on 13/03/2004, stating that no fingerprint could be detected. Stop. Thereafter, these arms and ammunition were sent for forensic examination by another memo being memo number crime /2004/3460 and received by the Forensic Science Laboratory on 02/04/2004. Stop. The scientific officer submitted forensic examination report Exhibit 12 on 30/06/2004. Stop. The report Exhibit 12 shows that the arms and the ammunition were received by the Forensic Science Laboratory by the memo number JHT/Exhibit crime /04/3460 dated 30/03/2004, and thus that there is no confusion whatsoever. Stop. Parachin. According to her, Exhibit A, Webley revolver number 35235 is the same which was seized by Exhibit 7 on 30/11/2003. The number of the revolver and the brand confirms it. The Exhibit 12 shows that it is a serviceable 0.38 bore revolver, which is a firearm. Exhibits B1, B2, B3 and B4 are the 4 fired cartridge cases seized by Exhibit 3, and Exhibit 12 reveals that these cartridge cases are from the same revolver. Exhibits C1, C2 and C3 are the fired bullets seized from the place of occurrence by the Exhibit 3. Exhibit D is the fired bullet recovered from the body of the deceased, and it was seized by the Exhibit 8. Exhibit 12 shows that Exhibit D was fired from the same revolver. Thus, it is proved beyond reasonable doubt that Exhibit D bullet was pumped into the body of the deceased from Exhibit A. Webley revolver number 35235, which, on the other hand, was discovered on being shown by the deceased under Section 27 of the Evidence Act. Apart from that, there are other circumstances connecting the accused with the crime. First, PW1 deposed to have received call from the accused 8/8:30 a.m. and she gave the receiver to her husband, whereupon deceased was invited by the accused to Rajabari Club. The deceased went out at 4:30 p.m. saying that he would go to Rajabari Club at night. Secondly, the dead body was found near Rajabari Club on the night of occurrence. Thirdly, death was homicidal in nature, caused by bullet injury. And fourthly, the explanation given by the accused under Section 313 CRPC of leaving the club at 8:30 p.m. was found to be false, as he and others were there in the club till 10 p.m. According to MS. Jahan, all these circumstances unerringly point towards the guilt of the accused without leaving any scope of doubt, and show the conviction and sentences are not liable to be interfered with. She submits that the appeal merits dismissal. Thank you.